Many times people will call and ask, what does it mean to have a premises liability case? Really what a premises liability case is when you are injured on the property of someone else's. Generally, we hear about slip and fall cases, and that's the most common premises liability case. There are also trip and fall cases, there are falling merchandise cases, there are ceiling tiles that fall off and hurt people, and even dog bites are considered premises liability cases. Most of these cases are regulated by statute. In order to establish that you have a viable premises liability case, you have to be able to prove one of three things. Either that the property owner caused a dangerous condition on their premises or on their property, and that's the instance such as someone mopping the floor, an employee of a store mopping the floor, they are the one that caused the dangerous condition. If they didn't cause the condition, the question is, did they know about a condition and didn't do anything to remedy the condition? And that may be where a customer calls and says, hey, there's some water on aisle 4, and the store management doesn't send someone to clean it up and someone gets hurt in the interim. So if they caused the condition or knew there was a dangerous condition, then they're on the hook. The other element of a premises liability case, if you cannot establish they caused the condition or knew there was a condition, the question is, should they have known that there was a dangerous condition on their property? And usually that's an element of time. Has there been a condition on the property for a long enough time that they should have found it and should have remedied the situation? For example, if it hasn't snowed for 3 days and a customer slips and falls on snow and ice, then the store is probably on the hook because they should have cleaned it up 3 days earlier. At our law firm, we take a number of premises liability cases, slip and fall cases, dog bite cases. They're actually referred by other law firms. Because the premises liability case, relatively unique, and they're difficult cases, there are a number of law firms that just don't want to take those cases. Part of the reason other law firms don't want to take a case is because the person that's injured is often participating in their injury. For example, when you slip and fall, you were walking. And some people like to blame it on the person doing the walking, saying that they should have been watching what they were doing. The problem with that theory is if you get injured in a slip and fall at a store, they spend millions of dollars in advertising to get your attention off the floor and get it on the products. There are many things to look at when you're considering whether or not you have a viable premises liability case. You're welcome to call us, have a free consultation and evaluation about your specific case, and there's no charge for that consultation.